Hi, everyone. Welcome. Thank you so much for joining us today, which is our last of our 5 webinars celebrating our 32nd annual employment law update. I'm Brittany Pierce, and today I'm joined by my colleagues, Hana Kern, Kristin Nealey Meier, and Shannon Lawless. For those of you who aren't familiar with our firm, Swanson is a full-service 40-plus attorney law firm based here in the Northwest. And each one of us presenters today are members of our firm's employment law group. We work with business owners and HR professionals to help them implement practical, creative solutions that protect their business from potential threats that can disrupt their workforce or business operations. You probably also heard each of us do a different webinar this week covering a variety of employment law topics. And today we're excited to come together and answer some of your frequently asked questions. In fact, we might have a few too many. We've got lots of questions and we're going to cover how many we can during our time, about 30 minutes here today. So if you've been to any of our seminars in the past, you know that we usually do federal, state, and employment law updates. And we didn't cover a full topic on that this year, but of course, everyone wants to know, what are new cases, what's going on, what's the latest in employment law? And a bunch of them, but really one that stood out, the Supreme Court decision that came out earlier this year, Bostock v. Clayton County. And this was actually, it was a consolidation of 3 different cases. Together, the decision really was a landmark decision for LGBTQ plus rights. And I'm going to tell you just a little bit of background of each of the cases that led up to this. The first one, the Bostock case, was this male employee had been employed for a long time at his company, and he had expressed some interest in a gay softball league. And shortly thereafter, his work was audited, his finances were audited, and they said, oh, we think your group might have mismanaged some funds. And so he was promptly terminated. Now, one of the other cases was a skydiving case. In this case, the employee was a skydiving instructor. And what he did was when a customer came to skydive, a female, he said, oh, don't worry, I'm gay, to make it more comfortable because you're strapped together, skydiving. The customer didn't like that. She and her boyfriend then complained to the company, and the company terminated him for misconduct. The third one was the employee of a funeral home, had been there a number of years, started as a man, and then some years later advised the company that he would be returning to work after undergoing gender assignment surgery as a female, and would be identifying as a woman and dressing as a woman, and wanted to prepare the company. And once that was disclosed, again, that employee was terminated. All of these claims were then brought under sex discrimination under Title VII. And there've been a split in a lot of circuits and a lot of different courts about whether or not this type of discrimination really falls under the sex discrimination. And we've got our Supreme Court decision that said, yes, it does. So discrimination against gay, lesbian, transgender employees is barred by Title VII because it is considered sex discrimination. And that is the case even when part of the decision is based on sex. So for example, if there was mismanagement of funds or some other basis for a termination, if even part of it was based on sex, then that is a violation. The focus here is really on individuals. It's not, on classes of individuals. It's was this individual discriminated against? So going forward, a tip for all companies is really to make sure you're appropriately training managers, decision makers on the fact that this type of discrimination is considered sex discrimination. You do need to have sensitivity training and make sure you don't run afoul of our landmark decision that came out. Another decision came out, victory for women, I suppose, is the Rizzo v. Ovino case. This is a Ninth Circuit decision that came out. And in this case, the plaintiff was an employee. She was a math consultant in Fresno County Public Schools. She had come from Arizona. She was a math teacher there. Then when she applied, as part of the hiring process, they used kind of a step pay scale. And the bases for what step to slot the person into was prior pay. So she was, paid less before, they slotted her in, and she realized that later some new hire male employees And in fact, a lot, if not all, of her contemporary males in the same position, some of whom were less experienced, less educated, every one of them were being paid more than she was. And that's because of this using the prior pay. So she filed this lawsuit, of course, and what the court found, the Ninth Circuit found, is that you cannot ever use prior pay to create a pay differential. I mean, that's just, what we've been talking about, is that just really keeps the wage gap alive and well, unfortunately. And the court, in fact, said, while the wage gap has been narrowed, it is not yet closed. And this is not doing us any favors to close it. Because your pay from your prior position is not related to the job you are performing in your new position. It should never be considered a factor. So therefore, the factors must be job related, and they cannot be based on salary history. So that was an exciting case that came out too, that everyone should be aware of. And of course, it relates to Washington's Equal Pay Act, which I think Shannon's going to chat about next.
Yes, thanks, Brittany. So the Rizzo v. Ovino case just segues perfectly into a discussion of Washington's Equal Pay and Opportunities Act. So Rizzo was, of course, decided under the Federal Equal Pay Act, but Washington updated its own equal pay statute, RCW 4958, in 2018, and that was the first update to that statute since 1943. Brittany, if you want to go on to the next slide, I will share a little bit of details just about what's in that act. So we've had a couple years to get up to speed, but I think some businesses are still making adjustments. So the first bullet point on here is sort of the main requirement of the act, which is similar to what Brittany was talking about for the Rizzo case. Basically, if you have two employees who are, quote, similarly employed, which means that they're working in very comparable jobs, they cannot be paid differently based on their gender, which means that if there is a pay difference, it has to be explained by what's called a bona fide factor. That could be that they have a difference in experience, education, the type of work that they're performing. For example, if one of them is a higher producer in terms of the dollars they're bringing in the door, a seniority system, but it cannot be a prior salary. That can never be a bona fide factor. So the Rizzo case was sort of already the case under Washington law. The Equal Pay Opportunities Act also prohibits a pattern or practice of giving career advancement opportunities to one gender and not the other. A great example of that I heard from one of the Washington legislators who worked on the law was the golf trip. If every year you invite all the male employees to go, on a golf trip with the big clients and you don't bring the female employees, that would be a violation of this law. In 2019, the legislature went back to the Equal Pay and Opportunities Act and added a couple more provisions. It put a flat out ban. Employers now may not ask about the salary history of a candidate. And then also for employers with 15 or more employees, they have to actually disclose wage ranges or certain wage information if there is a question from a job applicant or an internal candidate who's being promoted. So be aware that those new changes are out there. They are enforced by our Department of Labor and Industries, and so far it's been pretty understanding about the fact that employers are still learning that these requirements exist. But if your candidate complains, they will require you to provide this information. So I think we can look at the next question, and Kristin is going to catch us up on race and diversity, a big topic in this year.
Absolutely. So as I'm guessing all of you have been aware over the last few months, the topic of race has been at the forefront, and obviously that impacts employers in their day-to-day work, but exactly how does it impact employers? So there's two questions there: what's changed and what hasn't? So first of all, what has changed? Well, some of you may not know that in March of 2020, the Washington State Legislature passed a law signed by the governor that amended the definition of racial discrimination based on hair texture or protective coverings. And that happened at the end of March. So there might have been some other things that you were dealing with at the end of March this year. So that might have passed you by, but please note that that is actually law in the state of Washington. So for example, dreadlocks or different kinds of coverings or hair textures or anything like that, you can't require or make decisions based on that, even as we've talked about before, if that's part of a decision that your managers are making or comments that your managers are making to employees. And of course, the other main change that has occurred isn't necessarily a legal one, but certainly is a heightened awareness of race discrimination and issues surrounding race, not only in the culture at large, but specifically at work. So it's important for both your employees and your managers, really your whole institution, regardless of how large it is, to understand that race is an issue you're going to need to address. There's a wide range of ways to make sure that you understand what your employees' questions are, what your both individual actions toward employees and sort of institutional-wide hiring, training, disciplinary processes. Does race play a role in how? Have you ever even thought about that? Those are all questions that you're going to need to answer and analyze and determine what, if anything, that your workplace is going to do to address some of the issues that have been discussed in the last few months and will continue to be discussed. These are going to impact your ability to hire, your ability to retain, and a lot of these decisions and conversations are really uncomfortable. It is something that we recommend you have discussions about in your workplace. Now, what hasn't changed? Most of the law hasn't changed as a result of the racial discussions and everything else that has gone on this summer. But it's still really important, and you need to revisit, if you haven't recently, with your workforce, with your managers, what are the policies that you have surrounding discrimination? What are your processes for people reporting discrimination? Is your environment friendly to having a discussion if people feel that they are a victim of discrimination? The requirements for proving discrimination in court have not changed. They are still there. We just anticipate there's probably going to be more claims or more attention to claims. We'll see if that bears out over the next year. But it's really, really important that you have all of those policies in place and that you are following them and that you are continuing to train your workforce so that you can avoid any of the claims that may be coming up as a result of what has been happening. So this is going to continue to be an issue. We are certainly happy to answer any specific questions about how to address some of these issues, but certainly something to be aware of.
Okay, this one's me. May an employer ask an employee who is physically coming into the workplace whether their family members have COVID or have symptoms? So that's an easy one. The answer to that is no. You don't want to be asking whether their family members have COVID or have symptoms. And the reality is what you want to know is whether that employee has been exposed, right? You don't particularly care whether it's by a family member or somebody else. So the kinds of questions you can ask is that question, whether they've been exposed. Don't be asking about their family members. That's a more neutral question. So folks have raised, well, what kinds of questions can and can't we ask? And I did talk about that a little bit in my presentation. So if you have more information or want more information about that, my slides are available and they have that in there. But generally, you don't want to be asking questions of your employees such as, are they immunocompromised? Do they have some condition which makes them more likely to be susceptible to COVID? You can ask your employees whether they have symptoms. You can ask whether they've been tested. You can require temperature checks. You can require, as a lot of workplaces are doing now, the self-reporting questionnaires that we're seeing. So may an employer ask an employee why he or she has been absent? And the answer to that is yes. That is a neutral question. As an employer, you are entitled to know if your employee hasn't shown up, what's going on or why they aren't there. And you can ask that just facially neutral question of an individual why they didn't report for work. That is not viewed as a disability-related inquiry.
So for everybody in the state of Washington who has a workplace with more than one person, there are some requirements out there coming from a lot of different places in terms of what guidelines we have for worker safety and for how to start bringing your workers back to work, what phase you're in, all of the questions. So here we have a specific slide related to what the governor and LNI have issued as guidance for your specific industry. And in the first link there is business guidance for phases 1 through 3, depending on what county you may be in and what phase you may be in. And there's specific industries and types of workers. So if you have specific questions about agriculture, retail workers, anything like that, you can go to that first link and get specific information about what's required. There's also some information about kind of the enforcement actions that have been taken place. For example, on July 1 was the first violation with a fine that was issued for opening too early. It was a Yakima fitness gym, and they were fined almost $10,000 for opening in violation of the government's order. So, these guidelines are not just some things that you might be interested in, but are actually specific requirements for each industry depending on what phase you're in. Now, the second link there is a specific information and resources for you. And one of the things that I thought was really interesting is was this dashboard that provides information about enforcement and how many spot checks LNI is doing on different workforce, on different sites. You can see there's been education and outreach contacts, and there's been, as of September 15th, 2020, 173 warning letters issued, and then they come back and do another site check to make sure that you are following the guidelines and doing what you're supposed to do for your specific industry. You can also see that there have been 720 COVID-related inspections, and 240 of those resulted in violations. I don't know what the average fine is or if all of these folks were fined or not, but that is kind of gives you an idea of what the LNI inspectors are doing related to the guidelines that they have issued. Now, further down on this is some information related to workers' compensation claims. And if you heard my presentation on Monday, you heard me say that the LNI had come out and said that an employee just contracting COVID from a coworker is a claim that would be denied under workers' comp. And yet you see here on this graph that 3,000, which is a little over 3,000, about 81% of claims have been allowed. And there's 584 are pending, and just a few, 122 have been rejected. My guess, and I haven't done a lot of research into this, my guess is that most of the allowed claims have been healthcare workers who have contracted from patients or from visitors to healthcare facilities, hospital workers, etc., because that really is a risk that and a injury that has occurred on the job, not from exposure from a coworker. So although this is a different outcome from the comment that I had made on Monday. I still think it holds true that unless you're a healthcare facility, your workman's comp issues are probably not going to be a COVID-related problem that you will have to address. But know that L&I is out there, that they are inspecting. I don't know how many of these arise from claims from employees, from visitors, but as we've emphasized all week, it's really, really important to continue to be aware of the guidelines for your industry and your workers and follow through with those. So that's all I have for that.
All right, and I think if we want to advance to the next slide, I think that's me. Hopefully we can do that. There we go. Okay, so when we were brainstorming in anticipation of this presentation about what are our FAQs, employment issues tend to come up in groups for some reason. And my theory is that, you know, online dating apps is like feeling too risky with COVID. So people are turning to the workplace, because I have had no less than four different clients dealing with issues of employees having sex with other employees or with, you know, customers or other people that they're interacting with through the business. And this is a topic that makes employers really uncomfortable, because their employee's sex life feels inherently personal, and yet here it is very much affecting their business. So what I wanted to share just at the big picture is, as an employer, you have a duty to prevent sexual harassment of your employees and your customers. And if you're a public accommodation, like a restaurant or a hospital, or, you know, somewhere that people, the public can come, there now under Washington law is strict liability for harassment of your customers or the people coming into your place of business by your employees. Strict liability, that is a really high standard. So you as an employer are empowered by the law to interfere with your employee's sex life if that's what you need to do to fulfill that legal duty. That means you can and should prohibit manager-subordinate dating relationships or sexual relationships. You can and should prohibit your employees from hitting on people who come into the workplace. The nuance in this is that you need to make sure that when you are setting those rules and enforcing those rules, that you do it equally no matter who the employee is. You can't have a different rule or practice enforcing these rules as to men or women. If they are your employees, the same rule has to apply across the board. But there is no sort of assumption that you can't get into your employee's personal life when it is affecting your business and your obligation to create a safe and harassment-free workplace. So feel free to ask those uncomfortable questions or set those uncomfortable rules. And in fact, I think that now in COVID, that is something that you need to do.
All right, next up, independent contractors. You know, we still get lots of questions about these. I think it's just really tricky. People really want to have independent contractors, but they are generally disfavored under the law. You know, they are in Washington, and frankly, there's kind of a legislative tide that's trying to make them disfavored everywhere. So just be aware that if you do want to enter into an independent contractor relationship with someone as opposed to an employment relationship, you'll need to do it right. And so that means you'll need to do some things like have an actual contract that says they're an independent contractor. Lay out all the terms. They should be free from direction and control. The independent contractor should have their own UBI number, pay their taxes, be in a different type of business than your type of business. They should be doing work outside your typical operations. So really keep kind of some of those key things in mind if you want to have an independent contractor relationship. It's also tricky because different courts and different agencies, they all have slightly different tests So if you think, oh, good, I've made, I've passed, this particular agency's test, that doesn't mean you're necessarily in the clear. So that's why we recommend really thinking through whether contractor relationship is one you want as opposed to your traditional employment relationship. The downside, if you get it wrong, if you've misclassified, and by the way, misclassification can happen even if you've tried to set up the contract that says the words independent contractor, but in reality, the relationship looks more like an employment relationship. The company will be liable for unpaid taxes. It will be liable for unpaid overtime owed to that person, and that can be a real biggie. So there is a lot of risk. And so if you want to take on the risk, just make sure you're setting it up right and performing in practice like this is an independent contractor relationship, not a slightly hidden employment relationship that you may get caught for. So just be careful.
So before we get to this next question, I thought I would jump in and answer one of the questions we got in the Q&A box. So thank you for sharing that. The question is, can we require a doctor's note if someone is out sick for a set number of days if we put that in our policy manual? And if so, can we ask them to verify that there was an illness or injury, or can we only ask that if they're released to work? So if they are using their Washington or Seattle paid sick and safe leave that they get, you can only ask for verification that they were out, such as a doctor's note, if they have been out for more than 3 consecutive days. And be careful of that. It is not 3 consecutive days. It has to be more than 3 consecutive days. So you should put that in your policy manual if you do plan to ask for a doctor's note. However, if they hit that more than 3 consecutive days out of work, then you can ask for a doctor's note. And I just pulled up the statute because it gives them, or the regs from L&I, it gives a little bit of detail about how much you can ask. So it says that you can require verification identifying that the need was for an authorized purpose, so that they were out for sick leave, but you must not require that they explain the nature of the condition. However, if you do learn, and because often an employee will tell you, I was out sick, if you have reason to believe that they may not be safe to come back to work for their own safety or the safety of others, then you can ask for a release to work. So if you know they were out for surgery, you can ask for a doctor's release to make sure that they're safe to come back and do their current job. And of course, you can and should always be asking those COVID screening questions. If they have any symptoms, they should not be returning to work until those are cleared up.
Okay, I'll jump in with how do I comply with all appropriate laws when I have employees in different states. So to start out, in case anyone isn't clear, you do need to comply with the laws of the jurisdictions where your employees are working. So this means not only federal laws, but different states' laws, and sometimes different cities have laws as well that are often more restrictive, as we often see here in Seattle. And this is a particularly timely question with remote work, right? You might have employees working from states other than where you were located, and you didn't have that before. So generally, as I said, the rule is that the employment laws of the state where your employee is working will govern that employment relationship. So specifically, without doing a super deep dive, because we don't have a ton of time today, just to kind of touch on the kinds of things you need to be thinking about. Number one, payroll, taxes, and withholding. So there are federal and state requirements. If you work with a payroll service, they should be able to make sure that you are compliant with every jurisdiction that you need to be compliant with, but you do want to double check that. Different jurisdictions, different states, and even different cities have wage and hour requirements. You want to look at what are the different rest and meal breaks. Are there scheduling limitations? What are the overtime rules? Are there rules about timing of pay? How soon after a work week? Do you have to get the folks their paychecks? Sick leave, minimum wage, all these kinds of things can vary from state to state. There are different limitations on restrictive covenants. Those of you that tuned into Shannon's presentation heard about our Washington State restrictive covenant law. Different states might have restrictions on which employees you can have subject to, say, non-compete agreements. There might be limitations on those types of agreements. Workplace posters, right? We all love those workplace posters. Different states might have different ones you have to put up. Interview requirements, what can and can't you ask? We talked today about salary history. Criminal history is another one. Of course, you have to adhere to the higher standard. If the state that your employee is working in has a higher standard for some particular thing than the federal law, then you need to comply with that. This was just an overview. So there are lots of moving parts if you have employees in different cities and states. And so we encourage you to consult with your favorite employment attorney if that's the case. You know, we're pretty close to being out of time here. Kristin, do you want to tackle this in the next minute or so?
Sure. Sorry about that. Yeah, so just really quick, those of you who have been dealing with accommodations, ADA, listen to Hana's presentation on Tuesday. Hopefully you have a pretty good handle on what accommodation looks like. For mental health issues, those accommodation process is the same, their requirements are the same, but in practice, it looks a little bit different. And that's mostly because it's hard to necessarily identify if an employee has or needs a mental health accommodation. When you're talking about depression, PTSD, those are not necessarily the same thing as somebody who has vision problems or has, you know, it needs to go on light duty or something like that. So in a short answer is if you suspect or the employee asks that they need accommodation for mental health, you need to go through the process. And some of the accommodations that may work for you and the employee are an altered break or work schedule to give the employee some downtime, a quieter office space so that there's not a lot of loud noises and distractions, changes in supervisory methods. Maybe they need a you know, written instructions rather than just sitting there not quite understanding what a supervisor wants. But the bottom line is mental health issues need to be treated the same as other disabilities in requests for accommodation, and finding those may be more challenging, but still need to be done.
So before we wrap up quickly, we had another question in the Q&A box that I want to get to, which is what if, and this is our kind of worst case scenario, but it happens, your employee comes to work, they have COVID, and they give it to other employees. What do you do? And what do you do if they did not follow the standards for workers' safety that they are supposed to be following? Well, I mean, first of all, you know, it is the employer's obligation to provide a safe workplace. So if you have employees who have been exposed or who have contracted, you need to get them out of the workplace as quickly as possible and have them stay home for a quarantine period. On the CDC website, there is standards for when an employee should return to work after having COVID, and that's what I've been sharing with my clients to use as a standard for returning back. So you need to do whatever disinfecting or cleaning is recommended by your local health department. And if at all possible, I certainly recommend for those employees who were exposed at work and are quarantining, if you are able to pay them, certainly they can use any sick leave, but if you are able to pay them, that is ideal. We don't want there to be a financial consequence, if at all possible, for them being exposed at work. You can't stop them from filing a workers' comp claim, but unless they're an emergency responder or healthcare provider, it's probably not going to be covered in Washington State at this time. And then finally, if they didn't follow the standards, the employee who came to work in the first place and gave it to other employees, there should be disciplinary action taken. You know, wait until they have, you know, gotten through. If they have bad symptoms, let them get through that. But there should be a serious disciplinary action taken because they have put their coworkers at risk and they've fundamentally made it an unsafe workplace, which is unacceptable.
Great, thanks, Shannon. Thanks everyone for attending, and of course to my co-panelists today. I think we're about out of time. And you know what we try to do is we try to stay on top of all the latest employment law developments and share that new information. So if you're not already, please consider going to our website, which is linked right there, to get on our email alert mailing list. We also post updates to our website and our social media accounts. So feel free to give us a follow if you'd like to stay up to date on the latest and what's going on in the world of employment. So again, thank you guys all for joining us, and please feel free to send us an email if you have any questions. We're always happy to answer, happy to help, so feel free to reach out anytime. Have a great day. Thank you again.